Got it.
Appearances.
What do they own? No, there's no
Appearances.
Minimize sound. Make it minimize.
Appearances.
Yes.
Good morning, my lord. May it please, my lord.
Yes.
No,
My name is Dele Igbinidion, my lord. Dele Igbinidion is my name, my lord. I appear for the claimant. My lord, the claimant is present.
Yes.
Yes.
Grateful, my lord.
Appearance for the defendant. No appearance for the defendant.
See where the speaker did.
Yes, go ahead, please. Who is appearing for the defendant?
It's my learned friend, Mr. Idemudia Oahimire and Ojiaga have been appearing, but it appears they are not present.
Online at the moment.
It appears so, my lord.
Okay, no appearance.
Yeah.
Okay, this is my ruling. The defendant applicant filed this notice of preliminary objection brought under the inherent jurisdiction of this court on the 4th of May, 2023. Orders to wait, an order striking out this suit for lack of competence and want of jurisdiction, and for such other orders or further orders as this honorable court may deem fit to make in the circumstance. The ground of this application is as follows: that this suit was filed before the expiration of the pre-action notice. Hence, the claimant respondent lacks the competence or legal right to institute this action. Thus, the claimant has failed to fulfill the condition precedent to activate the jurisdiction of this honorable court. Notice of preliminary objection is supported by a 5-paragraph affidavit deposed to by one Osemokai Faramolu Ojiaga, legal practitioner, legal service unit, Ambrose Ali University, Epoma, with documents marked exhibits Zana A1 and A2, respectively, as well as a written address in compliance with the rules of this court. Above is served with the notice of preliminary objection. The claimant respondent filed a 9-paragraph counter affidavit deposed to by Mr. Patrick Ikeiwewa, the claimant respondent in this case. The documents marked exhibit PO1 and PO2, respectively, as well as a written address dated and filed 19th of June, 2023. The applicant's reaction filed a 5-paragraph further affidavit, further and better affidavit deposed to by one Osemokai Faramolu Ojiaga, legal practitioner, legal service unit, Ambrose Ali University, Epoma, with a document marked exhibit Zana A1 and a reply on point of law. Can you hear me? I don't know whether you are still online. Mr.
Yes, my lord.
Okay, very
Yes,
well.
I can hear very well.
Was heard very well. The application was heard on 7th of July, 2023, when Dr. Idigbe Oahimire of Counsel for the defendant applicant placed reliance on the environments contained in the applicant's supporting affidavit and adopted his written address in urging this court to grant this application. Also placed reliance on the further affidavit and the annexed exhibit and adopted his reply on point of law in reaction to the respondent's counter affidavit. And then counsel for the defendant applicant distilled a known issue for determination in his written address to it, whether the complaint filed in this suit can activate the jurisdiction of this honorable court. Arguing the known issue, then counsel submitted that it is tried that the question of jurisdiction is a threshold matter that is crucial to the adjudication of a case and cited AG Lagos State versus Dosumo and Madukun versus Ikendele citations provided. Nene Council cited Chapter 13, Section 1.11 of the Regulation and Scheme governing the service of senior staff 2017 of the first defendant as amended, and submitted that the claimant jumped the gun by instituting this suit before the expiration of a pre-action notice issued by him. He argued that during the period of the pre-action notice, parties are stopped from filing or commencing any action in court, and noted that the claimant has clearly failed to comply with this. Counsel pointed out that the claimant issued a pre-action notice on the defendant on the 15th of November 2021 and commenced this action in court on 18th of November 2021. Well, below the date stipulated in the provision cited above. And the counsel posited that it still commenced in default of pre-action notice where it is required is incompetent, citing the cases of Umukoro versus MPA, Amadi versus NMPC, and Eze versus Okechukwu citations provided. Counsel submitted that the action of the applicant in bringing the action is premature, and this court is therefore robbed of the jurisdiction to entertain the present suit. In conclusion, counsel submitted that the claimant respondent suit is grossly incompetent and urged the court to strike out same. Benin Esquire Counsel for the claimant respondent placed reliance on the respondent counter affidavit and their next document exhibits and adopted his written address in opposition to the notice of preliminary objection. Counsel settled for two issues for determination in his address to it. One, whether the defendant applicant's notice of preliminary objection filed on the 4th of May 2023 was filed out of time and incompetent before this honorable court. Two, whether the defendant applicant's affidavit in support of notice of preliminary objection dated and filed 4th May 2023 is irregular and incompetent. On issue one, Learning Counsel submitted that the law is tried that where the law provides for a procedure Sorry, the connection was lost. Mr. Ibinedi, are you there?
Lord, I'm here, my Lord. I'm grateful.
Okay, sorry about that. The connection was just lost. So I'm going to skip the summary of your submissions to save time because of the connection and go straight to the evaluation.
As a court please.
Just a moment. I've carefully read the processes filed by the learning counsel for the defendant applicants in respect of this notice of preliminary objection filed in this case. I've also read the counsel affidavit of a claimant respondent and the written addresses of both counsel in respect of the objection. I've thereafter settled on a known issue for determination in this application to read whether or not the notice of preliminary objection filed by the defendant applicant is meritorious. It is unarguable that the instant application touches on the jurisdiction of this court to entertain this suit. In Oputa versus Sumunakwe, citation provided, Yaya JCA held, and I quote, jurisdiction is a life wire of a case, and a court must have jurisdiction to entertain a case, otherwise its proceedings will be null and void and a complete waste of time. That is the reason why it is imperative to determine an objection to jurisdiction where raised at the onset, unquote. It is, however, pertinent to resolve the contentions of a respondent counsel that the supporting affidavit to the preliminary objection is incompetent before delving into the issue identified for determination. And then counsel for the respondent premised contention on the ground that Osemuka Faramolu Wajaga, who disposed to the supporting affidavit on behalf of the applicant, is also a counsel in this suit and had appeared as counsel for the defendant applicant before this court. Considered that it is unethical and against the rules of professional conduct for a legal practitioner to act as a witness or depose to an affidavit on behalf of his client in a case wherein he is also appearing as counsel. I've taken the pains to read the provisions of sections 10, subsection, that is rule 10, sub-rule 1 and 2 of the Rules of Professional Conduct 2007, and the provision is very clear. While it may not be ideal for a counsel to depose to an affidavit in a case in which he is appearing as counsel, the courts have held that this provision is only applicable to documents filed in his capacity as a legal practitioner, not as a witness. In this instance, the deponent merely deposed to the supporting affidavit based on his knowledge of the facts, and as such, it is not mandatory for him to affix a stamp and seal. On this, see Triumph Nigeria Limited versus Forex International AB, citation provided, where Ugo JCA held, and I quote, an affidavit deposed to by a lawyer in a proceeding in court is ordinarily evidenced in a case, see Jimo versus Minister of Federal Capital Territory, and so may not, by the mere fact of such deponent being a lawyer, make the Rule 10 of the Rules of Professional Conduct for lawyers applicable to it. And that is so, even if the said lawyer deponent swears to the affidavit in the course of his employment as counsel. It is only if such deposition of affidavit has to do with or flirts with the lawyer's core professional calling as a lawyer that it will be required to affix a stamp to prove that he's the lawyer that he claims there, unquote. However, without prejudice to the above position of the law, the practice of a counsel acting as a witness or deposing to an affidavit on behalf of his clients in the same case has been consistently and constantly frowned out by the court. See Ekpeto versus Wanogo, citation provided, where the court observed, and I quote, this is a very undesirable practice since it means the counsel is given evidence in a case in which he's appearing. Also, if there's a conflict in affidavits and evidence is called to clarify or resolve such conflict, the counsel who swore to the affidavit must give evidence. This is undesirable and should be avoided, unquote. Similarly, in Union Bank of Nigeria PLC versus NIDA, citation provided, the court frowned at the practice and warned, and I quote, this practice may result in the counsel stepping down in the case to be a witness, where, for instance, there is conflict in the affidavit of the parties, unquote. The above authorities have duly and clearly interpreted the provisions of the Rules of Professional Conduct 2007 under review, and in line with same, nothing stops the counsel from deposing to an affidavit or acting as a witness on behalf of his client in the same case. However, such a counsel will only be mandated to stop his representation or withdraw his appearance for such client if he's called upon to testify in the matter in relation to his depositions. In line with the above reasoning, I find that the submissions of the respondent counsel is not tenable. As such, this issue is hereby resolved in favor of the applicant. I so hold. The respondent counsel further contended that the deponent, being a legal practitioner, also have affixed the Nigerian Bar Association stamp and seal to the supporting affidavit. therefore posited that failure to do this is in breach of Rule 10, Sub-Rule 1 of the Rules of Professional Conduct. On this, I find that a thorough reading of the above rules reveals that it is mandatory for a legal practitioner to affix his MBA stamp and seal to any legal document prepared by him. Position of the law, however, reveals that failure to comply with this provision amounts to a mere irregularity which can be rectified. The Supreme Court has held in a plethora of authorities that failure to affix MBA stamp and seal to court processes does not render the processes void or incompetent, as same can be cured by subsequently affixing same to the processes. On this, see Sarakin, Yaki, and another versus Bagudu, another citation provided. It is, however, worthy of note that in the instant case, this court have earlier held that the deponent to the supporting and further affidavit did not file same in his capacity as legal practitioner, but as a witness. As a result, the rule cited above is not applicable to him, and his depositions in the supporting affidavit and further and better affidavit was as a witness sworn before the Commissioner for Oath of this court remains tenable. On this ground, I find no merit in the submissions of the counsel to the respondent on this issue, and same is hereby resolved in favor of the applicant. I so hold.
As the court
On the
noted.
sole issue formulated for determination in this ruling, the basis of the applicant's objection is that the pre-action notice served on the applicant is still pending at the time the respondent instituted this suit. The applicant's counsel wants us to rely on the Abu Zali University Law 1999 as amended and place specific reliance on Chapter 13, Section 1.11 of the regulation and scheme governing the service of senior staff 2017 of the defendant as amended, which provides as follows, and I quote, "No legal proceeding shall be instituted and or commenced against the university or any agent in the course of his official duty by staff of the university unless 30 days notice of such intention is served on the university," unquote. The above provision is clear and unambiguous, hence shall be given its ordinary and plain meaning. The positions and processes before this court reveals that the claimant wrote a pre-action notice to the defendant on the 15th of November 2021, which is to run for 30 days as stipulated in the conditions of service of the defendant. Further reveals that before the expiration of the 30 days stipulated in the above provisions, the claimant commenced this action on 18th of November 2021. The respondent counsel, however, contended that upon service of the pre-action notice on the applicant and before the expiration of the 30 days notice, the respondent was dismissed by the applicant without trial, and same was published by the defendant by its new news bulletin dated 2nd December 2021, that is claimant exhibit PO2. In this regard, I find that it is settled law that where there is a statutory requirement to be met before an action can be maintained, such requirement must be duly complied with before the court can duly assume jurisdiction over the matter. In Fans and Another versus Author Nigeria Limited and others, citation provided to JCAL as follows, and I quote, "It is also a settled principle of law that where a statute or contract stipulates the issuance and service of a pre-action notice, that stipulation generally constitutes a condition precedent to the assumption of jurisdiction by a court of law, with the effect that failure to serve such pre-action notice constitutes an impediment to the full assumption of jurisdiction by the court, especially where the issue is timeously raised by the party who ought to receive the notice," unquote. Also see Yaki and Another versus Bagudu, Another Supra, where Ubuta JSC held, and I quote, "A pre-action notice has been held to be a condition for the exercise of the right to bring the action and not an abridgment of that right." See Anambra State Government and Others versus Marcel and Others citation provided. The applicant's counsel in support of the instant application Sorry about that.
Sorry, my lord.
It's okay. I'll go on. The Applicant's Counsel, in support of the instant application, quoted the provisions of Chapter 13, Section 1.11 of Exhibit Zana A2 meagerly in his written submissions. In doing so, he left out part of the provisions, which is key to an holistic interpretation of the provision. Hence, I find it pertinent to reproduce the omitted parts as follows, and I quote, "This is to allow for internal resolution of the matter, and the university management should not do anything that will adversely affect the staff within the 30 days, underlining mindful emphasis," unquote. It is noteworthy that the depositions of a respondent that was dismissed during the dependency of the pre-action notice and the part of the provision reproduced above were not disputed by the applicant, and same are deemed admitted. In view of the above, this court can act on same, and in this wise, I find that the action of the applicant during the pendency of the pre-action notice is a breach of its own provision. In this wise, the Latin maxim ex topi causa non originatio, that is, no action can arise out of an illegal act, will come to play. In a nutshell, this connotes that the applicant cannot be allowed to benefit from its own illegality, as the defendant, having breached the provision on pre-action notice, cannot claim a right under the same provision. In addition, the trial position of the law is that an objection premised on a procedural requirement must be raised timeously before any further step is taken by an entitled party in the suit. The importance of this cannot be overemphasized, as failure to raise an objection on time in such instances implies that same has been waived. See Fan and another versus Autoport Nigeria Limited and others supra. The record of court discloses that while the claimant instituted the suit on the 18th of November 2021, the defendant applicant filed its notice of preliminary objection on the 4th of May 2023. This means that the applicant brought this objection almost 2 years after the filing of the claimant's suit and after trial has commenced, with the claimant having given evidence in chief. This matter whereafter was adjourned for a cross-examination of the claimant before the applicant brought the present objection. While there is no doubt that the issue of jurisdiction can be raised at any time, at any stage, even at the appellate court for the first time, as it goes to the root of the case, where the objection relates to procedural irregularity, same must be raised timeously. The defendant applicant in this instance, however, did not raise his objection on time, but left it till almost 2 years after they have been served with the complaint in this suit. In this wise, I find that it is too late in the day for the defendant to raise this objection. The applicant having tarried for 2 years before entering an appearance, defense, and belatedly raising the present objection. Premised on the above, and in line with the above reasoning, I hold that the notice of preliminary objection of the defendant applicant in this instance lacks merit, and same is hereby dismissed. No others to cost.
Stop, please. What pleasure?
Stop, please.
Very well, thank you. So we'll take it. Is that Mr. Ojaga online?
Yes, my lord. Yeah. Yes, my lord.
Okay.
Our amendment. My lord, we are most grateful. This is Dele Igbinidio, my lord.
Lord, we are most grateful, my lord. This is OF Ujagi, my lord.
So what date? Again, a date.
Could I pray? I know it's adjourned for ruling. The defendants have a motion to bring in their statement of defense. I wonder if my lord will be graciously minded to take it so that on the next date we can then proceed with
I thought they have already.
Okay, I've taken that.
Okay. Mr. Ojaga, I thought you had regularized your defense. Is it true you have a motion? Is it there, Mr. Ojaga?
Yes, my lord, I'm here, my lord. My lord, I'm here, my lord.
Yeah. Yes.
Let me check.
Before this comes.
Let me check, my lord, because I'm not seeing where I am now. I'm not with the file of that particular case. I only came to receive the ruling, my lord.
Okay, so just let's take a day. Let's take a day.
My lord, I'm sorry, my lord. I apologize. Delay, Benedict, my lord. I've noticed that on the 7th of July, they regularized their process, their defense process. I apologize, my lord. I think it's my oversight.
Okay, very well.
So all processes are, as copies, all processes are.
At the court process.
If we could be guided by my lord's diary.
Okay, the court clerk is there.
Sorry, my lord.
No, let the court clerk
I'm grateful.
suggest dates for us.
30th of October is convenient, my lord.
It's not convenient, my lord. We have two matters in your
7th
honorable
of
court that
7th, what about 7th of November?
Let me check. It's convenient.
7th of November.
That one is convenient.
Is it convenient for
convenient for us here, my lord?
For cross-examination of CW1.
It's
Yes, my
convenient, my
lord.
lord.
7th of November is convenient, my lord.
Okay, 7th November 2023 for further hearing.
As copies.
At the court places, my lord.
My lord, we are most grateful. We will not ask for copy.
It's okay, have a good day.
Thank you, my lord. We are grateful for the sound ruling, my lord.
Call the next case.
Case number NICN/ABJ/347/2020 is between Emmanuel Usu and 1, the governor of Edo State, 2, the Attorney General of Edo State.
No, the second on my list, wait. The second on my list is
Sorry, my lord. It was an oversight, my lord. Sorry, my lord. It's NICN/BN/14/2020 between Nosakari Michael Omoregbe and 1, the Inspector General of Police, 2, Nigeria Police Academy UDI, 3, Police Service Commission. Parties absent, my lord.
The claimant is present.
Can't see it on the screen.
Appearances.
May your lordship be so pleased.
Appearances.
May your lordship be so pleased. Can you hear me, my lord?
Yes.
Okay,
Go
my
ahead.
name is President. My name is President Idigbe.
Yes.
Yes, sir. With me, sir, is ROA Otuakena.
Your appearance is for.
My lord, with me is ROA Otuakena. We are both for the claimants.
Your appearance is for who?
The claimant, my lord.
Okay.
And the claimant is also present here.
Any appearance for the defendant?
They have not been represented throughout this proceeding, sir. Since the beginning of this case.
Very well.
Yes, sir. Lord, this for adoption.
Yes, the case is for adoption. Yes.
Yes, ma'am. Yes. We have filed our written address, sir.
Yes, go ahead.
Dated 17 February 2023, sir. That's right, dated.
All right, go ahead. Are you ready? Go ahead.
17th February 2023, sir. We
Dated
seek
when?
to adopt our written address, sir. Yes, it's dated 17th February. 17 February 2023, sir.
And filed when?
Yes, but filed 2nd of March 2023.
Filed when?
2nd of March. 2nd of March. Yes, sir.
Very well.
We adopt same as our argument for the claimant, sir. We are urging your lordship to grant the reliefs as sought in our statement of claim, sir. The reliefs as sought in our statement of claim.
Very well.
Yes, sir. My lord, there was a mistake in paragraph 2.2, sir.
You should have done that before adopting.
I'm sorry, my lord.
What's that about?
We made a mistake there, sir. The release we sought there is different from what we sought in our statement of claim. It was a mistake, my lord. Sorry.
Very well. I'll look at the extant statement of facts. No problem. Now, give me a date. Joseph, are you there?
30th of October is coming in, my lord.
20th.
30th, my lord, 30th.
Did you say 20th?
No, my lord, 30.
Is that a Friday?
30, 30th. It's a Monday, my lord. 30th, not 20th, 30th. 30.
30th is over three months. That's over 90 days.
Please.
Today is 28th, 29th August.
Okay, 19th October 2023 for judgment.
As the court pleases, sir.
19th of October.
Yes. 23rd October, my lord.
19th October 2023 is a Friday, is it not?
Yes, my lord.
What day of the week is that?
19th is a Thursday, my lord. Thursday.
Oh, okay. 23rd of October. Sorry, Mr. Igbokem. 23rd.
23rd of October.
23rd October 2023 for judgment.
As the court pleases, sir. That's a Monday. As the court pleases, sir.
Very well.
Thank you, Lord, my Lord, for the indulgence, sir.
Right.
As court pleases.
Wish you a pleasant holiday, sir.
Have a good day. Yes. For the next.
Case number NICN/ABJ/347/2020 is between Emmanuel Uso and the governor of Edo State, 2, the Attorney General of Edo State. Claimant present, my lord. And defendant absent.
Claimants absent.
Claimant present, my lord.
Okay.
Defendants absent.
Claimant present, my lord.
Very well. Appearances.
With the greatest respect to my noble lord, my name is Emmanuel Uso. I appear for myself.
Yes. Who is on the other side?
Yes, my lord. My lord. Principal State Council. I appear for the defendant applicants.
Yes, Kanyip.
Yes, my lord. My lord, we do have application.
Go ahead, Kanyip.
Dated and filed on 21st of July.
Your connection is really bad. I can't hear you.
On 21st of July. Manos,
Yes.
we have applications before your lordship.
What's the application about?
Yes, I'll stop you. My lord, the application is dated and filed the 21st day of July, 2023.
3rd of July.
21st day, 2117.
21st of July.
Yes, my lord.
Yes.
My lord, in the application, we are praying for your lordship order to allow we, the applicants, to amend our statement of defense to read statement of defense and counter claim. And we desire to amend say in line with the underlying portion of Exhibit FA attached to the said motion.
Now, Mr. Also, have you been served?
My lord, I was just served. I was served 2 days ago.
Okay.
I was served 2 days ago. My lord,
So
the
what is
purpose
your
of this is
stand?
to
Are
truncate.
you?
My lord, we are opposed to it. It's just to truncate the proceedings for today because the matter was ordinarily fixed for.
Kadiri, are you there?
Yes, my lord. Yes, my lord.
Okay, now, this application you're talking about, because I can't hear Mr. Also again. Now, this application is just to amend the title of your defense, or is there something else?
Yes, there's counterclaim. We are counterclaiming that the vehicle in issue, which was the Mitsubishi, should be returned to us.
Sorry.
The Itato
So
statement of
now you are
defense
just
without
bringing in your
counterclaim.
counterclaim. You are just bringing in your counterclaim. Is that what you're saying?
Yes.
Yes.
That's overreaching.
It's not right.
Adam.
It's not right. You can amend.
Let me speak.
Both of you have closed your case, and I don't know the evidence.
My lord,
I mean,
my lord,
yes.
this particular application is overreaching. No evidence was led in respect of counterclaim. If the application was to align the evidence already led on the records, my lord, there will not be objection to it. But bringing a counterclaim where the claimant will not have opportunity and privilege to cross-examine the witness on the issue is brought mala fide and overreaching, and the courts are clear on the issue. Moreover, you are serving the process 2 days to the proceedings, which was already fixed. My lord, this is very deliberate and it should not be allowed. My lord, in order to meet up with time, we tried as much as possible this morning because we were served just 2 days ago to file a counterclaim and a written address. As we speak, our counter affidavit is being filed in the registry if your lordship will consider it. But on the alternative, if he wants to take his application, my lord, I will just be allowed to argue on points of law, and then your lordship can rule on it. And also at the same time, allow us to adopt the written address so that we don't go back and forth in respect of this issue. While your lordship is ruling on the entire case, can make ruling in respect of the application that has been filed.
Very well. Now, Kadiri.
Yes, my lord.
Kadiri, are you there? Yes. Now, I don't know why you are bringing this application so late in the day, because already parties have closed their cases, their respective. We have adjourned for adoption. You are bringing in a counter claim, which will require the other side to file a defense to it and to call for that evidence. So you want us to reopen the entire case again based on your counter claim at this stage of the proceedings. And you don't think it's overreaching?
The rules of the court give your lordship the discretion to allow this counter claim. My lord, even the rules of the court say that whenever we are filing this counter claim, the additional statement on note we will rely on, we should file it along with the counter claim, which we did. What my learned senior is telling my lord is not correct, that we are filing it to overreach. Even in our address, in our written addresses, we are even urged your lordship that the vehicle be returned. It was when we had a second perusal at our pleadings that we now see that we didn't have a counter claim to the effect, and we don't want to leave your lordship in a vacuum in discharging that discretion towards us. That's why we were directed to file this application. When this application is filed, the law allows my learned senior to file his own defense of a counter claim. When we now plead with your lordship to reopen our case just for the counter claim, so that we can try the counter claim. We know with the time of the lordship. And even the written address we have filed, we don't intend to file further written address, because we believe
I still don't get you. You want another bite at the cherry. You once this application is granted, the other side will file a defense to it. You call evidence. We'll start all over again at this stage of the proceedings. You mentioned one thing. You said granted this application is at the discretion of a court, but the stage of the amendment matters, because you are asking for an amendment that will cause a reopening of the case all over again, and you feel that is not overreaching because new evidence is come, something you did not envisage or you didn't plead before. It was when you filed that you realized that you needed to file this, and you feel that that discretion is meritorious and can be granted in your favor. It's okay. At this stage, maybe I have a duty to, of course, hear your motion. So, but Mr. Uso.
Yes, my lord.
Uso, your counter affidavit is not before me. So,
yes, my lord.
And I believe that I should enter a well-considered ruling on this issue. So I'm thinking that maybe we should adjourn it to the new legal year so that all the processes will be before me and I can
as your lordship
well consider. So that is just my thoughts. In the interest of justice at this stage,
as your lordship
I think both of you should join issues on it so that I'll consider all the processes holistically. So just take a date so that we'll come back to argue the motion to amend. But I must warn you, Kadiri, that
yes,
because of this adjournment, I'm going to award a heavy cost against you. Because you are coming too late in the day. And you have wasted the time of the court as well. So you should have, as a counsel, as a serious counsel, you should have at least an overview of your case and pleaded what you needed to plead before now, not at the stage of adoption. Now you come in and telling me that you want to amend and you want to counter claim at this stage.
We are sorry, sir.
Yes,
Only that the higher authority in our office, they look at it and they think this should be filed before your lordship.
Yeah, authority. Well, then you should have, at this stage, the only amendment that can be granted is one that aligns with the evidence. The one that aligns with the evidence already before the court, not for you to reopen your entire case in order to counter claim. No, you don't do that. But you have filed a motion and of course it will be heard. So let's take a date.
My lord will be asking for costs. We'll be asking for 500,000 naira cost.
How much?
500,000, my lord. My lord, it took this court
30,000.
500,000. It took this court great pain to set all these proceedings. It took your lordship time to prepare for this proceedings. My lord, it also took us time to come to court this morning, especially in this era of scarce resources and economic crunch. All we needed to do today has been truncated by the application, which is also not very by the defenders. My lord, the sole purpose was to truncate and arrest your lordship this morning. Urge upon your lordship to give punitive cost.
You know the purpose against justice. My lord, sir. In relation to the application of my Benin friend for court, we want to urge your lordship to allow court to be in the course. My lord, we cannot be said we are not diligent.
We have
filed our final written address. We also filed our reply on point of law. My lord, this case at the stage at the tip.
Address me on cost, Kadiri. Address me on cost.
I have pleaded
They have left
that you allow the court to be on course, to be in the course. Because according to what my friend is telling your lordship, we are diligently. We are not before your lordship without our final written addresses. We have filed our final written addresses. My lord, even somewhere in our final written addresses, we are even enjoying your lordship to allow the. It's not easy that we didn't plead it. We pleaded because that of all the.
I'm sorry, my lord. I don't know whether he wants to take his.
No, you are saying.
No, I'm taking an objection.
No, you are indicted of that.
Now,
Wait,
let me take an objection. My lord, wait now.
It's okay, Mr. Oso. Please,
yes,
he's on his feet. Now, Kadiri.
Yes, my lord.
Now, listen to me. We have passed that stage, the stage of arguing whether we are going to take the motion or not. I'm going to take the motion. I've already decided. And the issue on ground now is the issue of cost. So you have said that
Yes,
cost, and I've recorded you.
Yes, my lord.
Very well.
I thank my lord, sir, for the attention.
I agree on the date. Okay, please give them a date.
9th of October. No.
Is that convenient?
October.
Is it conflict with it?
What date?
We'll say that if it's convenient to them.
It's convenient to me.
9th of October is convenient for Mr. Oso.
Because we are already in this process.
No. Night is okay for me.
What day of the week is that?
9th of October, it's a Monday, my lord.
Yeah, I'm trying to put for 10 because we've been in.
Is it 10?
It's better there.
Night is okay for me. 10 is not okay.
No, it is.
My lord, it seems Mr. Kari is not okay with the night.
Okay. Take another date.
Okay, sir. Let's take a date that is convenient for the both of you.
If you like, take December. Your governor will soon leave that place.
Night is okay for you. For November. 9th of November is okay for you. Okay. Check. No, it's for motion. For motion. Why not 18?
13th of October. 13th.
No, it's a Friday. It's a Friday. Say it's not complex. Sorry, is it complex for you? 10th of October.
10th.
Yes, please.
So that it doesn't have excuse, I will take it.
10th of October, my lord, is convenient for both council.
10th
10th of October.
The agreement of council defendants applications is adjourned to 10th October 2023 for hearing. A cost of 50,000 naira is awarded against the defendant to be paid on or before the next adjourned date.
God pleases.
As God pleases.
I'm grateful to your lordship.
Yes, what's the next case?
Okay, my lord. The next case is NICN/BN/41/2019, and it's between Mr. John Nwalobe Ebusele and EcoBank Nigeria Limited. Parties absent, my lord. Oh. Parties absent, my lord.
Very well. Appearances.
May it please my noble lord. My name is Dele Igbinedion. My humble appearance is for the claimant, my lord. Claimant applicant, my lord.
Yes. Who's on the other side?
My lord, it's the law firm of Obaro Ume and Co.
Yes.
And
Who's on the other side?
it's C.O. Irabo had always been appearing before him. So C.O. Irabo has always been appearing. He was in court on the last date, which was on the 26th of June.
Okay.
2023, my lord. And the matter was adjourned to today. He was in court. We are surprised that he's not here today.
I think there's proof that it was served with.
As the court pleases.
I'm not sure. Okay. Okay. I'm not sure that they have been served and they are not here because from what I'm seeing here, I see a motion for. Joseph, is the court clerk there? I don't think he's online. So, Mr. Igbinaja, you have
My
a
lord.
motion.
Yes, my lord. We
You
have
a motion to amend.
yes, my lord. We have two motions. We are withdrawing one, and we will be praying court to move the other one, my lord.
The one you want to withdraw is dated.
My lord, it's dated the 30th of November, 2022, my lord. We crave indulgence to move in terms of the motion paper, my lord.
You want to withdraw and you want to move in terms. I don't get it. What are you talking about?
Oh, we withdraw. I'm sorry, my lord. We withdraw the motion.
Dated when?
My lord, it's dated the 10th October, but filed on 30th November 2022.
Motion dated 10th October 2022 and 30th of November 2022 is hereby struck out.
As court pleases. We are most grateful, my lord.
There is a problem. I cannot find the proof that the defendant is aware of today's date. So I've checked. I don't know. Maybe we have to take it up for your motion. Is there any counter affidavit?
I'm sorry, my lord. The audio is
I don't have
slightly.
any counter affidavit before me.
There is no counter affidavit, my lord.
Yes, is the court clerk there?
Yes, my
Where
lord.
are they? Okay, so
Yes,
is
my
there
lord.
any counter affidavit? Is there any process from the defendant in respect of this motion to amend? Have you filed anything this time?
No, my lord.
Nothing in the court record. Do you have the proof of service with you? Do you have the proof of service that it was served with this sitting, this virtual sitting was served with the notice?
No, my
Is
lord,
there
I
any
don't
proof
have
with
any
you?
here with me now. No, my lord.
No proof.
My lord, may I say something, my lord?
Yes.
The today's date was agreed by counsel, by us and counsel for the defendant. That was on the 26th.
But did they send him a link? Did they send him a link of this virtual sitting? That's what I'm interested in. Because after adjourning the matter, they're supposed to send a link to him so that he can join. So that's what I want to confirm.
That's God, please. But at the very least, he should have been in court. Mr. Uso and Mr. Kadiri, they were there in the court. So at the very least, he would have been in court. He could have joined from the link of the court.
Yes. James, are you there?
Yes, my lord.
Okay, so have you confirmed? Was this out with the notice of this virtual sitting?
Yes, my lord. Mr. Joseph was the one that handled the
Okay, so the defendant's counsel was served.
I've sent Rafat out to confirm from Mr. He's not here right now.
Okay, Mr. Villager.
My lord.
I still have like another case, so we are going to stand it down just to confirm whether I got the notice. So we'll stand it down to confirm whether I got the notice, then we'll come back to it.
As copies, I'm grateful, my lord.
Please do that. Yes, call the next case.
Case number NICN/BN 32/2020 is between Mr. David Salifu Onobu and one S. Lloyd Recruitment and Training Limited, 2 Golden Transport Company Limited. Part subset, my lord.
Appearances.
May it please my lord. A.A. Atemwabo. With me, my lord, is my learned friend, O.L. initial, Itekao.
O.L.
Itekao, O.L. initial. Itekao, I-T-I-E-K-H-A-O for the claimant applicant.
Yes. Who's on the other side?
My lord,
I can see Mr. Okay. Please unmute yourself. I think he's on the other side.
Yes, my lord.
Yes. Announce your appearance.
With proprietary to this court and SIOK for the first defendant.
Yes. Who's for the second defendant?
My lord, my learned friend.
My lord, no appearance for the second defendant. And the last, the Zoom link service was actually served in my client's office in Lagos. So I requested that they should allow the sheriff or the courier service to take it personally to the office of the second defendant. But that was the last I heard regarding the matter. I didn't even receive the link until this morning when I called my Lelen friend to request for the link. I had issues with my phone.
That's okay. So, Mr. Atemwa.
My lord, the processes have been served on the first, the second defendant. There is, I'm reliably informed by the registry that there is proof to that effect.
Okay. Yes, you have a motion. Mr. Okay, are you opposing?
My Lord, we did not file any counter affidavit to the motion. So we are not opposed.
Yes, move your application, Mr. Atemwa.
Yeah, we are grateful, my lord. If my lord indulges us, we beg to move the motion in terms of the motion paper.
Your motion is dated on file.
It's dated on the, it's dated 28th day of February and filed on the 1st day of March.
Very well. So I take it, Mr. Okay, no objection.
No objection, my Lord.
Return date. Agree on a date.
Please.
Yes, it's James there.
What?
Give
Yes,
them a
my
date.
lord.
Give
Okay,
them a
ma'am.
date.
It's October 9th convenient.
October 9 is a Monday, it's convenient.
It's convenient.
October 9th, 2023 is convenient, my lord.
Very well.
My Lord, before my Lord is off today, we
Yes.
actually we filed an application to substitute our witness. It was dated on the 1st of March. Since
I've
now
already
that,
adjourned the matter. You should have raised that now. I've already.
I did not on my mind. As the copy is, we can see withdraw maybe in the next day.
You leave it against the next adjourned date. So order as spread. Leave is granted to the claimant applicant to amend his complaint and statement of facts in line with Exhibit AA and AA1 attached to this application. The deeming order is refused. The claimant is to file clean copies of his amended processes within 5 days and is to serve the defendants with copies of same. Defendants are at liberty to file their consequential amendment if need be within 5 days of being served with the amended processes. The claimant is also to endorse the amended statement of facts with an endorsement of this order. By agreement of counsel, this case is adjourned to 9th October 2023 for hearing.
As please.
We are grateful, my lord.
Yes.
We are grateful, my Lord.
My lord, may I
Yes,
crave
Mr. Benedict. Let me ask James, have you been able to see the proof?
Yes, my lord.
Okay, it was served.
It was served. The generated proof.
Okay.
His phone number is there, my lord.
Very well.
Besides that, my lord, I believe he's with us now. He's in court.
Okay, he has joined in.
Yes, I phoned him and I sent him the link, and he has. I saw him a few moments ago.
Okay, very well. Mr. Rabo, if you are there, announce your appearance.
May please, my lord.
Rabo, are you there? You have to unmute yourself.
My name is C. I'm here, my lord.
Very well.
Okay, man. May please, my lord. C.O. Irabo.
Yeah.
For the defendant, sir.
Yes, you have in receipt of the motion to amend by the claimant.
Very well, my lord.
Are you opposing?
We are not opposed, my lord.
Yes, Mr. Igbinaja.
My Lord, if it pleases my Lord, we humbly seek to move our motion dated the 2nd day of June, the 22nd day of June 2023. And filed on the same date in terms of the motion paper. We are most grateful to the court. My Lord, we also filed clean copy.
Is the case parted?
No, my Lord.
No, so
Hearing
I'm going
has
to
not commenced.
refuse the deeming order.
That's copy.
22nd of June, 2020.
Yes, my Lord. 22nd of June. Thank you, my Lord.
What date? What date?
My Lord, if we should be guided by the
Yes, give them a date.
Okay, my Lord. 30th October.
Court registry.
30th October, 7th November, and 9th November.
7th November. 7th November is convenient for us. Subject to my Lord convenient. 7th November.
7th November is convenient, sir.
My Lord, the 7th November 2023 is convenient.
7th November.
Yes, my Lord.
Order as read, leave is granted to the claimant applicant to amend his originating processes in this suit in the manner proposed in Exhibit A attached to this application. 2, leave is granted to the claimant applicant to file his further witness statement or no additional list of documents and other processes in this suit. The deeming order is refused. The claimant is to file clean copies of his amended processes within 7 days with an endorsement of this order, and is to serve the defendants with advanced copies of same. Defendants are at liberty to file their consequential amendment, if need be, within 7 days of being served with the amended processes. By agreement of counsel, this case is adjourned to 7 November 2023 for hearing.
Scott, please.
Scott,
We are
please.
grateful to the court.
Well done. Enjoy
Thank
the
you,
rest of your day.
Thank you, my Lord. We are grateful. Permission to exit the court, my Lord.
Thank you, my Lord. Thank you, my Lord. We are grateful, sir.